1:30 in the afternoon. We are located in the third floor conference room of the Bonner County Administration Building, 1500 Highway 2, Sandpoint, Idaho. We are streaming online via Zoom and YouTube. Is there anyone in attendance in need of special assistance to see, hear, or participate in these proceedings? Please take note of the hearing procedure on the screens. I will submit my written decision within 5 business days of this hearing for these files. At this time, I'd like to leave the room as soon as I find the flag in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, for which it stands, one nation, indivisible, with liberty and justice for all. Or just went away from me. All right. Are there any changes to the agenda for today? No. And any announcements? Anybody? No. Are there any corrections or changes to the December 28th, 2022 hearing minutes? Then I declare them approved. Okay, we will start today with file S0006-22 subdivision Golden Tee Estates 12th edition Valiant LLC. The applicants are requesting to create a 10+ lot subdivision from an approximately 20-acre parcel. The property is zoned recreation and is located off Highway 200 in Section 2, Township 57 North, Range 1 West, Boise Meridian. I have no conflict of interest with this project, so I am turning it over to staff.
Thank you, hearing examiner. Travis Haller, Assistant Director, Bonner County Planning Department, for the record. The file before you is S0006-22 Golden Tee Estates 12th edition. Proposing a subdivision of 30 residential lots and 1 tract. The applicant, Valiant Idaho LLC, project rep is Jeremy Grimm with Whiskey Rock Planning and Consulting. So this proposal is part of a conditional use permit for a planned unit development, or PUD, Golden Tee Estates, and that's under conditional use permit C832-05. There's the site plan that was presented to us. This is off Highway 200 near Idaho Club. There are, I believe, 4 blocks being presented, and the lots vary in size from about 2 acres all the way down to I think right around 6,000 square feet. Approximately. And this is the CUP file C832-05 that was approved in 2006. This is the issuance. And so this kind of outlines kind of the foundation for this subdivision. And A7 is noteworthy because this is what authorizes the deviation for the roads, setbacks, lot size minimum, and lot depth to width. And so we could read that if you'd like, but it's there. So the subject site is, like I said, located near the Idaho Club. It's got direct access off Highway 200. It's roughly 20 acres of unplatted area. It's zoned recreation and has a comprehensive use of resort community. So the wetlands are off to the left there. So there's your lot, and you can see the wetlands kind of, they really go through kind of the middle left there all the way to the highway, and they just touch the property on the bottom right there. The different colors, the green and the purple, are different wetlands delineations types, where the yellow is the outline of the property. The slopes off to your right there, the legend's a little hard to read. It's very small, but where there is no red or yellow, that means the slopes are less than 15%. The yellow refers to slopes between 15 and 30%, and the red is referring to slopes greater than 30%. Environmental factors: the site does contain slopes over 30%. The site does contain mapped wetlands. The site does not contain any mapped water bodies, streams, lakes, or rivers. The site contains two soil types: the Pend Oreille rock outcrop complex and the Pywell Hoodoo complex. Both are classified as noted there, and the parcel is not located within a floodplain. Water and sewer, a will serve was received from TIC Utilities, saying they have the capacity to serve the proposed 30 lots, the full subdivision. Electricity is provided by Northern Lights, natural gas by Avista, fire, Northside Fire District, School District, Lake Pend Oreille School District 84, ambulance by Bonner County, and hospital district is the Pend Oreille Hospital District. Agencies notified. Sorry. Out of here. December 13th, and they're all noted there. We received a few agency comments back. DEQ had their standard response, which is not file specific, but are general guidelines. DWR responded, there's conflicting water right ownership. I believe the applicant will go more into depth on that one. PhD responded, there is no PhD application submitted. The applicant will need to submit an application to PhD for sign off on the final plat. Bonner County GIS responded, they will need a road name. One was not provided. And Bonner County Road and Bridge, these are private roads that are being proposed, so no comment unless the road does become public. And then the Bonner County Engineering Department responded. They reviewed the plans, the stormwater and erosion control plans, and the road plans that were submitted, and they deemed them incomplete. And that has been given back to the applicant's representative and are part of the conditions of approval in this. No other agencies responded, and no public comments had been received up to the time this presentation was presented. The following sections of the Bonner County Revised Codes apply to this. There was 12268 refers to the application process and kind of goes through, as well as 12 BCRC 12-643, which refers to the right here. Let me get my notes out. Which refer to the process where the commissions takes a look at it. But what should be added here is 12-126, which outlines the hearing examiner's roles, and which address that the hearing examiner does have the authority to hear these files, in this case, the subdivision file. So so all these, we can go through them if you'd like. I'd like to hit on the large ones. Okay, so you can see off to the red there on the right-hand side, provided. So we can go through the code standards 4 that are based on the BCRC code, what is required and what was provided. So I'll just go through the ones that see conditions of approval that are outlined there. Otherwise, we can assume that they have been met. And so anytime you see the C conditions of approval, this is all in the conditions of approval. So like 12-620 there, required easements, constraints, reserved land areas to be shown and marked on the plat. that's in the conditions of approval. And so we can go through all of these. The big one is the urban services and the water supply here. And so for lots less than 1 acre in size, urban services are required. And this is where we received the will serve letter from TIC, and that's what we require in order to meet those services. The road name, we talked about that. A unique road name will just need to be reserved and shown on the final plat. Road standards here, this is kind of a big one. The associated, the PUD that the CUP that was previously approved, the C832-05, talks about a deviation from the private road standards to the minimum of International Fire Code. And within that, even though they're deviating from the standards, it is going to be a paved private road. So it's going to meet those IFC standards. The other one is the 12-624D, the public road frontage. Current code does require that any lots less than 5 acres in size need to directly front and have direct access to public roads. That's another deviation that was cited in the conditional use permit that was approved in 2006. So the conditions of approval up there, pretty standard. Those are outlined. 12-642B8 talks about the proposed method of water supply, sewage, and solid waste disposal. That's in the condition of approval, but it was really addressed in the previous CUP, and that's in there as well. You'll see that in the conditions. So if we kind of go through this, the other big one is the 12-7.2, the grading, stormwater management, erosion control. That's the one where the engineering department looked at it, said, hey, we need more information. We're deeming this incomplete. So all these things will need to be addressed in order for the applicant to get full final sign off. What we're doing here is we're saying, yes, this meets all the conditions as outlined in Bonner County Revised Code. There are things that need to be updated before they can do that, but they can meet those. So finding of facts, this kind of goes through the summary. Number one is that this is a previously approved plan unit development proposal under the file C832-05. It provides to deviate from the standards. It's got maximum lot coverage permitting up to 45% coverage on lots of 6,000 square feet or smaller, rear yard setbacks, lot size minimum, public road frontage and access, as well as the standards for construction. Number three, the subject property is about 20 acres. It's located in Section 2, Township 57, Range 1, West Boise Meridian. A few other finding of facts. This pretty much goes through the rest of them. The TIC utilities provided the will serve letter for water and sewer. The site does contain mapped wetlands, and it does have slopes over 30%. The conclusion of laws, the proposed subdivision is in accord with the purpose of this title and the zoning district in which it is located. The site is physically suitable for the proposed development. The design and the proposed subdivision will not adversely impact the natural resources. Public and private services are adequate for the needs of future residents or users. I'm paraphrasing here now. The proposed subdivision will not cause circumstances to exist that pose residents or the public at large to be exposed to safety concerns. I think we can read the rest there. But the big one to take away is this proposed subdivision is designed to comply with the design standards set forth in subchapter 6.2, as well as it is in accord with the Bonner County Revised Code. And so these are the conditions of approval that the applicant will need to meet in order to get final approval. And so again, this further goes with the criteria that we looked at. Number two, the fire suppression plan was submitted, and so it will need to be addressed on the final plat as denoted in those following bullet points. The second one down there, the defensible space plan shall be denoted on the plat. So all this will need to be shown. And then three, the road name we talked about. Everything else, I don't think I left anything out. Number 8, the proposed method of solid waste disposal. Number 10, the parcels of land need to be indicated for what use they're going to be used for. 12, it talks about the private road standards. 14, the applicant's engineer shall provide inspection reports for the county engineer's review and final inspection. That's standard for road construction purposes and subdivisions. 18 is the stormwater management report and erosion control plan was prepared by Welch-Comer engineers and surveyors and was submitted. These plans shall be updated and resubmitted as they were deemed incomplete by the Bonner County Engineering Department. And that needs to be done prior to recording on the final plat. 21, a geotechnical analysis shall be required for proposed building sites, roads, driveways, or other development where any of the following conditions apply, where the natural slope equals or exceeds 30%, and it does. And so a geotechnical analysis will be required. 22, a wetlands delineation report shall be required where any land disturbing activities are within a designated wetland area. If the applicant can prove that no land disturbing activities will take place in the outlined wetlands as shown, they will not need to provide a wetland delineation. And then 23, part of the conditional use permit that was approved, there was a wildlife corridor plan. I was unable to find that, so I added that condition in. So that should have been met with the original CUP approval. It's just, I assume it's out there, but I would like it for the records. And so it should satisfy the Idaho Fish and Game issues that were contained in back then from the 2006. So that's just kind of bringing everything up. So overall, after reviewing this, this proposed subdivision project is consistent with the Bonner County Revised Code based on the standards review, finding of facts and conditions of approval and conclusion of laws in the staff report. Staff recommends approval subject to the conditions of approval if they're met.
Thank you. You actually answered my one only question.
All right, thank you.
Thank you. Okay, so at this time, we will have the applicant stand up and make their presentation.
So you have your two. All right, thanks. Yeah, you should. Just share. You're still sharing.
Great, thank you so much. Jeremy Grimm for the record, owner of Whiskey Rock Planning and Consulting, representing Valiant Idaho LLC, the Idaho Club, Mr. Haberman today. Here before you, working on the next edition of the Golden Tee Estates, the 12th edition. And I'll just walk through some of the elements of the application and answer any questions you may have. First and foremost, the original conditional use permit, plan unit development C8332-05 authorized a large scale plan unit development on this 879 acre site. 386 acres devoted to residential development. In total, that PUD approved 458 dwelling units. On the original PUD, there are some site-specific conditions that authorize a deviation from the standards from Bonner County Revised Code Title 12. And condition C3 allowed for the phasing of the project to allow separate filing of plats, which is why we're here today. We're making further progression towards that project build out. You may or may not be aware, this project was, I guess I'll say, interrupted by a bankruptcy The current owners purchased this project out of bankruptcy and sort of adopted it at that point. But what you'll see on the left here is the original PUD plan and approval showing all the different phases and the eventual build out. And we're talking about the westernmost portion of this planned unit development, specifically the area highlighted in green here. This is from the originally approved site plan from April 12th of 2006. And these are the lots that we are platting. And of course, you probably recognize a preliminary plat. It's kind of like a yellow light. Many of the conditions and elements that are associated with staff's recommendation are incredibly expensive, require a lot of further engineering. But this application represents the basis for all those assumptions, and based on the engineering that's been done, everything is viable. So we just need to respond and get final approval for those stormwaters and related plans once we get preliminary plat approved. The Bonner County land use map is for resort community. The star represents the site that we are talking about today. The Bonner County zoning is recreation for the area. And this is just a aerial image showing the site in relation to the rest of the planned unit development and resort. Just a zoom in up there if you are not familiar with the site. When we look at Bonner County Revised Code, look at a preliminary plat, application, the contents, we've met those standards. Standard 2 boundary lines to the tract drawn to scale, location dimensions of areas for proposed lots, contours showing the shape of the land, proposed method of water supply, sewage disposal, and solid waste. Accompanying the application, road design, plan, and profile prepared by a stamped and signed Idaho licensed engineer, demonstrating the ability to comply with the minimum applicable road standards. And the applicant is not even required to have a land survey performed on the property at this point, but we've already gone ahead and done that, of course. This is a overlay of the aerial with the preliminary plat. So you can kind of see how those lots will lay out on this knob. And it's quite an elevated knob above the rest of the golf course there. This is the actual preliminary plat that was submitted with the application, 20 acres, proposing 30 residential lots in 5 different blocks. One track, 2.06 acres in that one track, which is private open space. The lot sizes range from 5,650 square feet to 1.46 acres, the residential lots. The road is at less than 10% grade, compliant with IFC, and also has an IFC compliant hammerhead. We've done preliminary stormwater design showing that the stormwater is manageable on the site, and we've done utility designs and shown that there'll be hydrants with 1,000 gallons per minute capacity. Zooming in a little bit further, this is leaving State Highway 200. See the first and 5th block here. The lots in this block range in size about 9,000 square feet, 8,800 square feet. And then the southern portion includes these lots with a hammerhead. And this is where we do have one lot that is a little bit smaller, 5,650, but within the tolerance of the original approval of the planned unit development. We have prepared and completed a preliminary utility design showing the connection to the TIC utilities and related hydrants. We do have a will serve letter from TIC utilities, no more than 30 single family residents to be constructed within the subdivision. This is our typical road section and profile here. 2 10-foot travel lanes with 2-foot gravel shoulders on each side, ditches. The finished road grade here, as in the preliminary engineering shows, is less than 10%, 9.83% as you come up that knob, State Highway 200. And we've done preliminary stormwater calculations that show that the site is feasible for stormwater control. I did want to just address a couple of the statements from Ms. Molly McCann in the letter I just received a few minutes ago. First and foremost, she's asking about the PUD timeline. As I mentioned, this PUD was approved, file C-83205. The property went into bankruptcy, lengthy legal dispute and related court matters brought it out of bankruptcy. And the current owner has been diligently pursuing the project, and that is typically the standard by which a permit extension or a permit is valid as long as you're diligently pursuing it. Ms. McCann also raises questions about TIC utilities and the DEQ. TIC, the Idaho Club for short, utilities is in fact regulated by DEQ. They communicate regularly with the utility operator about their holding pond levels. The Idaho Water Resource comments show that we do have valid water rights. There was a corrective letter by Luke Bates from the Idaho Department of Water Resources on 12/19/22, revising his initial concern and confirming that the property owner does have water right 96/96/46, which is the distribution source for the potable water on the site. Ms. McCann also raises questions about Panhandle Health. Of course, all final plats, as we proceed through this process, we'll go to Panhandle Health or have equivalent language notifying owners that they need to secure Panhandle Health approval. Wildlife, the original plan unit development was extensive. That file is an inch plus thick, and it does include a wildlife corridor study, and that was all originally incorporated into the approval of this planned unit development. So it's a bit redundant, but we're happy to provide, the county has a record of it, but happy to provide those studies before final plat. And regarding the wetlands that she raised issue with, there is a provision in 12/732 that allows for an exception for the delineation of wetlands if there's adequate building sites on a lot outside of the wetlands. And the only lot here is lot 1 that does have wetlands identified from that National Wetland Inventory map that was shown by the staff. And as you can see on that lot, there's the majority of that lot is outside of that designation. So there's plentiful building locations on that lot, not in the wetlands. Other than that, we are more than happy to abide by all conditions that staff recommended, and appreciate your consideration and entertaining questions.
Just in regarding to the TIC LLC, do you know the operator's name?
Well, the managing member is Bill Haberman, owner of it. I don't know his operator.
Just to address Molly, I guess, in that, once you get his name, you can look it up on DEQ's website and find out his licensing. More about it.
Sure.
That is the easiest way to find out if that operator is licensed. Okay, I actually didn't have any other questions. Okay. So I am going to go ahead and read the rules of testimony. If you wish to testify, you will need to please state your name for the record. Public testimony is limited to 3 minutes per person. You may give your 3 minutes to another person, so they have up to 6 minutes to speak. No one will be allowed more than 6 minutes. Public comments are limited to the specifics of this application. If you agree with another speaker, please just acknowledge agreement. No need to repeat the information again. Any personal or derogatory comments about another person or their position will not be allowed. Clapping, cheering, or booing will not be allowed either. Is there if anyone has any written statement, would they like to enter it into the record at this time? Is there a call for, I'm asking for supporting public testimony either in person or online? Okay. You know who they are? Reg, you can go ahead.
I'm sorry, I do not want to be in support. I just had my hand raised at the wrong time.
Well,
I'll go ahead.
yeah, is there any other supporting testimony at this time? Okay, and then we'll go ahead and start into the opposing testimony and go ahead, Reg. You have 3 minutes. Please stay within
Okay.
that time.
Thank you, Reg Crawford, Sandpoint, Idaho. Just to begin, I'd like to say I'm having a little difficult time hearing you when you're not talking directly into the microphone. But other than that, I want to point out that the planning director, Mr. Gabel, was made aware that the public file on this application was incomplete. The staff report mentions the planned unit development several times, but the file on it was not provided for public review. Furthermore, the PUD permit is over 18 years old. As we've hopefully learned from the Trestle Creek Marina court decision, permits this old need to be reevaluated for current conditions. In fact, wasn't there a requirement that portions of the work be completed on a timeline? Bankruptcy or not, 18 years is a long time, and this PUD for hundreds of parcels, it should be reevaluated to ensure all development requirements were met. And again, the public did not have access to this. I would feel like a quote, diligently pursuit of this even has a time frame. There is no information on the TIC LLC Bill Haberman public drinking and wastewater system with the staff report, nor is there any information on it recorded with DEQ. Mr. Grimm states there is a letter and a plan, but again, it was not made available to the public. This is redundant. This part right here is redundant from past hearing examiner hearings, but as the code has not been rectified, it bears mentioning that the hearing examiner is not a part of the subdivision code. Regardless of the hearing examiner code states that the hearing examiner can, the subdivision code does not. To vary from the revised code sets the county up for risk. Again, I'm running out of time here. The required wetlands reconnaissance and delineation reports are also not part of the public record, and in fact, are merely added as conditions of approval. I'm sure the public would prefer proof of this documentation. Furthermore, there's an incredible amount of items that are listed as conditions of approval rather than being required before this application is approved. It seems that this is less planning and more approving. The lack of required documents for public review, the archaic date of the PUD, the lack of proof of water and sewer provisions, the hearing not being before the zoning commission, and the lack of completion of the required delineations all make this file ripe for procedural error arguments. Any decision on this application should have and should still be postponed until all the applicable documents are available for public review as required. And again, I see the county addressing the concerns that they were made aware of, but the public did not have access to these documents. Thank you.
Is there any other opposing testimony online or in person at this time? Jennifer Wood? Are you?
Can you hear me?
Yes, we can hear you.
Okay. Hi, this is Jennifer Wood for the record. And I'm just calling as a concerned citizen of the county. We haven't seen a lot of subdivisions come up yet. And the thing is right now, I just don't feel like we have the infrastructure to support a subdivision like this. And this is just the tip of an iceberg of what they have planned. When you're talking about that many homes, you know, do we have the fire to support that? I certainly know we don't have the schools to support that when they're scrambling right now. The other thing is this kind of housing is just increasing the problem that we're seeing right now. The more we cater to this sort of development, the more people are going to need services, the more we're going to need service workers. And the thing is, we're already very short on being able to provide housing for that. The growth is out of control right now, and I just see that that's going to add to this problem. So as novice as I am to the planning and zoning technical terms, I do know that we just don't have the infrastructure right now to support that kind of growth if this is just the beginning for what they have planned on Highway 200. Thank you.
Thank you, Jennifer. Is there anyone else online or? Already asked them. I skipped over if there was anyone that was neutral. Is there anyone in person or online that was neutral to this? No. Okay. Then I am going to ask if the applicant would like to come up and rebut the comments that they have heard.
Thanks so much, Jeremy Grimm, for the record. Reg, I hope you can hear me. I'm trying to speak into the microphone. Yeah, just to address a couple of the comments from Reg and Jennifer. First and foremost, the TIC Utilities is regulated by the Department of Environmental Quality. The infrastructure that Jennifer mentioned already exists. This this approved planned unit development included upsizing of wastewater lagoons, water, etc. And this was all taken into account at the initial approval and design of the planned unit development. This is simply a phase within that approved subdivision and planned unit development. So the infrastructure exists. There are declining account balances that show what capacity the utility has. In regards to Reg's comments on wetlands, as I mentioned, Bonner County Revised Code 12732 does make an exclusion if there are areas on the lot where there are buildable areas outside of the mapped designated wetlands from the national map. And I guess finally, Reg mentions all these conditions, and for those who aren't frequent participants in this, those conditions are fairly typical and customary of any municipality or government entity. No developer would go to the fine-tuned expense of detailing, engineering, stormwater, all that design for a preliminary plat. This is a mother may I yellow light, proceed, but here's what we need to finalize it. So I just want to make that clear, that those conditions are very typical. Most of them are very minor. And of course, all the detailed engineering will get started once we receive preliminary plat approval. So what we've submitted at this point is design and engineering in accordance with the code and the application requirements, and sufficient to show that this project is feasible. In fact, we've gone beyond that. The code doesn't even require a survey to be performed on the property to get a preliminary plat. So again, this is a yellow light to get us to the next step so we can get that information before the county approves the final plat. And we will provide all that before the county approves the final plat. Thank you.
Okay. Was there anyone that wanted to address from the planning department? Okay. Maybe you could go ahead and reiterate my role of overseeing these subdivision.
Jake DeWell, Planning Director. So we did talk to legal counsel on the authority of the hearing examiner. I think this is Brian brought up at least once before. So 12-126, if I remember the code section correctly, grants authority for the hearing examiner to make decisions on variance files, conditional use permits, special use permits, and preliminary plat subdivision. So this isn't the final approval of this subdivision. That final approval is done by the board per state statute. All final plats have to be approved by the board. So it will go to the board. The preliminary plat stage doesn't require board approval in our code nor in state statute.
Thank you.
Yep.
Okay, at this time, I'm going to close the hearing to public testimony. And I'm going to deliberate for a minute over some of my notes. Okay, so I just want to reiterate what was just said by Jake Gabel there, the planning director, that my approval does not mean this is a green light go on this project. Obviously, there are several steps that need to happen if I were to approve this. And I do believe, though, however, the applicant has done a very thorough job of following the code, comprehensive plan, following guidance from the planning department, engineering, road and bridge, all of those departments that have been involved. They have addressed comments that have come into them, and I think that they are doing their due diligence. I understand the time frame of 18 years sounds like something has just sat and gathered dust, and all of a sudden people are excited about it again. However, there were other outstanding conditions and issues that were going on leading up to this point. And again, I just want to reiterate my approval, if I give it, does not mean this is a green light go on this project. There are a lot of hoops and steps that have to be taken where that happens. And as Director pointed out, it goes to the commission as final approval. It's not on me. I'm not saying yay or nay on this as far as that goes. So I just want to make sure that's clear because that has been a question that has come up in the past when I have heard subdivision applications, and I just would like to make that statement clear. Okay, so at this time, I approve project file S0006-22 requesting the creation of 30 residential lots and 1 tract on a property zoned recreation and located in Section 2, Township 57 North, Range 1 West, Boise Meridian, Bonner County, Idaho, finding that it is in accord with the Bonner County Revised Code as enumerated in the following conclusions of law, and based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further adopt the findings of fact and conclusions of law as set forth in the staff report or as amended, and direct planning staff to draft written findings and conclusions to reflect this decision and transmit to all interested parties. This action does not result in a taking of private property. The action that could be taken to obtain the approval of preliminary plat is to complete the conditions of approval as adopted. Okay, so I am closing file S0006-22 at this time. And we are moving on to file V0022-22. Lot size minimum and depth to width variance, Valiant. The applicant is requesting to create a lot at 2.9 acres where 5 acres is required and 6.6 to 1 depth to width ratio where 4.1 is allowed. The property is zoned rural 5. The project is located off Bayview Road in Section 19, Township 54 North, Range 2 West, Boise Meridian. I have no conflict of interest with this project. So I am turning it over to the staff.
Good afternoon, members of the public, hearing examiner, Tyson Lewis, Bonner County planner for the record. The request sounds a little different. We ended up getting a revised site plan that actually changed the acreage from 2.9 to 3.0-ish. And then also, where 3 to 1's required, it's actually, it's not where 4 to 1's required, it's where 3 to 1 is
That's
required.
what I was.
Yeah, that got
I
changed
saw that.
around as well. So I was I had a preliminary staff report built for this file, and then I was out for 2 weeks due to some family emergencies, and a coworker, a co-staff planner, was nice enough to write this up for me. So some of what I'm presenting is fairly new to me, but I will do my best to do it justice. Same gist. So we're gonna do a little project summary. So again, the applicant's requesting to create a 2.9 acre lot where 5 acres are required, which is now 3.0 acres or 3.03 roughly, as you can see here on the site plan on the left. I think it says 3.03 now. And depth width ratio of approximately 6.6 to 1, where 3 to 1 is allowed, not 4 to 1, because the lot's not over 300 feet. The request was, like I said, revised, changing the smaller lot to 3.03 acres from 2.9 acres. This is just a environmental features map, just to show there really aren't any environmental features on this particular parcel. There's a few spots of slope, but those could be, you know, holes from ice, whatever the LiDAR picked up when they flew Bonner County. So there are no wetlands. There's no slopes that are mapped by the USGS. It's pretty much flat and dry. So the existing parcel conditions, depth to width is difficult to calculate depending on where it's measured from. We're now going with the definition you see at the bottom there, which is lot measurement. The depth of a lot shall be considered the horizontal distance from the midpoint of the front lot line to the midpoint of the rear lot line, or the most distant point of another lot line if there is no rear lot line. Just to kind of clarify what depth to width is. Even surveyors, we all have different kind of interpretations. Bonner County Revised Code doesn't give us a specific mathematical formula that makes it very clear and concise for all properties. So depending upon the shape, it can be measured differently. But where the surveyor and planning came to is this calculation that you know, proposed lot 1 would be approximately 1.25 to 1, somewhere in there. Lot 2, approximately 6.65 to 1. And also it would be, you know, 3 acres where 5 acres required, which is about a 40% deviation. Just some current property details. The parcel size approximately 8.05 acres. It's unplatted. The zoning designation is rural 5. The land use designation is rural residential, 5 to 10 acres. Primary access is off Bayview Road. And the services the property enjoys right now are Selkirk Fire Rescue and EMS, Northern Lights Incorporated for power. The property is served by individual well and septic. Again, the property does not contain any map slopes of greater than 15%, because anything greater than 15% would have shown up on that GIS USGS layer. Doesn't contain any mapped wetlands, and it's in SFHA Zone X flood hazard zone, which is very low probability of flooding. So, so this is just a little write-up on what's around it. So, you know, the site, rural residential, 5 acre, 8 acre parcel developed with a couple residential structures to the north. Also R5, 5 acre parcel with residences on it. East, there's you know, 5 and 6 acre parcels that are fully forested. Just kind of what's around the subject property. A little bit of background. The first description I could find for the subject parcel without doing too much digging in the assessor records was warranty deed 418124 that was recorded in January of 1993, which makes this property fully conforming. It's prior to that date of non-conformity, which is November 18th, 2008. So no matter what, it is legal as is. The applicant purchased the property approximately June 30th, 2000, according to the bargain and sale deed under that instrument number. The subject parcel has not undergone any changes since the applicant's purchase. No right-of-ways have been subtracted from it. No easements have, you know, lessened its size. It's always been the same size since purchase. But the parcel does not contain sufficient acreage to bisect and meet the requirements of R5, which is 5 acres. These are the standards of review. basic code sections that we go through. The applicant or application was deemed complete. General provisions, the request is not out of line with Bonner County Revised Code. Something they could apply for. Variant standards, you'll see the next slides for the breakdown of the 3 variant standards that we review for. The basic breakdown of those. So we'll get into the real nuts and bolts of variances. There's 3 main review standards, and one is conditions that apply to this property that don't apply generally to other properties in the same zone or vicinity, which conditions are a result of lot size, shape, topography, or other circumstances which the applicant has no control. So the property hasn't changed since the applicant's purchase. It's always been roughly triangular between 2 roads. While it is unique in the surrounding area, the existing shape of the property is no bearing on the non-conforming status of the property, since Bonner County Revised Code Title 12 has no regulations restricting any particular lot shapes, only that they meet the depth to width and lot size minimum. So the request for the variance to the lot size is not a result of the shape of the property as existing. The request for the variance results from the desire to subdivide the property, the proposed parcel into 2 lots, or the lack of adequate land area as bought by the applicant to subdivide the parcel in accord with its current zoning designation. In the absence of the desire for the subdivision of the subject parcel, the need for a variance would not arise. So the subject parcel does, however, have an existing non-conforming depth to width ratio of approximately 6:1, 6:1 to 6.5:1, depending on where your angle of intersection is. Those were calculations that we've come up with and the project representative come up with. So per Bonner County Revised Code, the required depth to width ratio for this property is 3:1, not 4:1. 4:1 is only when the property's width is over 300 feet. And in this case, that width measurement was not that far. So, the applicant's requesting a slight increase from the current depth to width of 6.6:1 to 6.6:1, but again, the need for this variance results from the desire to subdivide the subject property, not because the property itself is in need as is. In general, there are no unique conditions that apply to the property that don't apply generally to the other properties in the same zone or vicinity that are a result of lot size, shape, topography, and or other circumstances over which the applicant has no control. The second main review standard for a variance, this is the one that tends to be the most important and usually the hardest one to overcome, is that special conditions and circumstances do not result from the actions of the applicant. So staff found that there's lack of any unique special conditions on the subject parcel that do not result from the actions of the applicant. If that's a double negative, that's a tongue twister. As noted previously, the existing shape of the parcel does not constitute a non-conforming in terms of the lot size variance requests. The property existed in its current size and shape when bought by the applicant, and the need for the variance results only from the applicant's preference to subdivide the property into 2 lots. The third major variance review standard is that, basically is going to harm the neighbors or the public health, welfare, and well-being, to synopsize that. And in this case, there weren't any agency comments or public comments indicating any conflicts with public interest, and the granting of this variance will be detrimental to the public health, safety, or welfare, or material injurious to the properties or improvements in the vicinity of the subject parcel or lot. Therefore, there weren't any comments that said this could directly affect this. However, the second condition of the variance standard was not met. So this one is okay. Agency routing went out on December 13th, 2022. These are the agencies that were routed. Just kind of synopsizing their letters, the Department of Water Resources. They didn't have any specific objections, just guidelines for existing or future wells and uses, including, claiming ownership and what those wells could then be used for. They mentioned irrigation standards and, maximum flow rates, that kind of thing. Panhandle Health District also didn't give any specific objections, but did say that, the detail, the existing septic system, and also that they request a site evaluation for any future systems, or advise that they get a site evaluation before dividing the property. No other site-specific comments were received from any other agencies. So staff has concluded that this project is not consistent with Bonner County Revised Code, and staff recommends denial. These are the findings of fact. These are just basic property facts. That it's got access on Bayview Road. That's a public right of way. Doesn't contain any slopes, doesn't contain any wetlands, no frontage on a lake or stream. These are just property facts. So with that, I'll open it up for any questions from the hearing examiner. I think, is that it?
I don't have any. You answered it with the ratio thing. Thank you. Okay, so at this time, we'll ask the applicant to come up and make their presentation.
Some quoted, I think 12-812, there's a lot, the definition for lot measurement. So that definition is still a draft form that has yet to be adopted. So, right, yeah, so it's not founded in code yet. It's a proposed change by staff. We're working through the process to get that changed. So just a heads up, the current, what's in Bonner County Code is the current definition for lot coverage, or sorry, lot measurement, so. You pulled it out of our draft, yeah.
Jeremy Grimm, owner Whiskey Rock Planning. For the record, I am representing Patrick Valiant, no relation to Valiant LLC, who was the previous file. This file is VAR 022-22, a variance for minimum lot size and depth to width ratios for 1575 Bayview Road, Athol, Idaho. So just to bring contextual relevance to this, the subject parcel is highlighted there in teal on the map. So south of Carywood, east of 95, on the way to Bayview. You can see the area in general has a fair amount of subdivision, lot splits, and related divisions. So I wanted to show you some comparable properties in the vicinity. First of all, I want to make clear that this is not what we're looking for. This is an example of a hypothetical variance in the middle of a bunch of full sections of land. That is not the case here. What we're seeking a variance for is something very different. The subject parcel is yellow on this map, and over the course of the last day or two, I started analyzing all the other lots in the vicinity. Starting in the upper left, I didn't have enough room to list those, but there are 15 lots in that subdivision that do not meet the 5-acre minimum standard, as well as all of these other lots: 3.2 acres, 2.9 acres, 1.6 acres, 2 acres, 1.9 acres, 3.5 acres, 0.75 acres, 2.9 acres, 1 acre, 4.8 acres, 2.3 acres, 2.7 acres, 2 acres. So within a half mile of this property, I'm taking the arrows out just so you can see it a little more clearly, there are 30 parcels that do not meet the minimum acreage of the rural 5 zone. I threw those all with their RP numbers into just a simple Excel and showed that the average size of these 30 lots is 2.86 acres. The mean size is 2.66 acres. So what is requested and being proposed actually is larger than both the average and mean size of the 30 non-conforming lots within a half mile of this property. That's just and I have that older site plan. I apologize, it's now 3.01 acres there. Corner. So when we look at depth to width ratios, the subject parcel is with the red star there. This is a parcel directly across the street. I don't even know how you formulated depth to width on that one, but it seems difficult. Here's another one, subject parcel with the red star. This is to the southwest, depth to width of approximately 10 to 1. This is another one, southwest. The red star is the subject parcel with a depth to width approximately 11 to 1. And this is one north of the property with a depth to width of 5 to 1. So as staff pointed out, there are 3 primary elements to help you make your findings that you need to make in a determination of a variance. The first is there are conditions unique to the property, including size, topography, and it talks about other circumstances, which I would suggest this applicant and this parcel fits into that other circumstances. It's a triangular shaped land abutted by 2 roads, surrounded by over 30 parcels or 30 parcels that do not meet the minimum lot size for the zone. Special conditions and circumstances do not result from the action of the applicant. The applicant didn't create this lot, didn't design it, didn't build it. So they have not created the circumstance of the lot shape. And finally, that the granting of the variance is not in conflict or injurious to properties improvements in the vicinity, which seems pretty clear considering that there are no agency remarks and there are many other lots in the area, smaller in size. So another thing I want to bring up is a comparable approval. This was in 2021. This was for a variance on a property abutting this property, file VA 006-21. Per the notice, the application was for deviation from minimum lot size in order to divide approximately 9 acres into 2 lots. So it seems all very similar. And in fact, that variance on the abutting property was approved. Summary proposal, the applicant's requesting a minimum lot size variance 20% for the subdivision of a 9.019 acre lot into 2 parcels. 1 5 acres and 1 remainder, which is exactly what this application is requesting, identical to their neighbors. And the conclusion and approval granted by Planning Director Milton Orlington was that the proposed administrative variance is in accord with the proposed Title 12. The action does not result in taking private property rights. So the subject of that variance is this red lot right here. Abutting or adjacent, I apologize. I think it's abutting at the end of that triangle. But the point being is the neighbors were considered for variance for the exact same purpose on an abutting lot. And the resulting plat is Webb Estates, where they split lot 1 into lot 2. Lot 1 and lot 2, and lot 1 is below the 5 acre minimum. So the concluding remarks, conditions are unique to this property. They existed. The existing property shape is unique. It's non-conforming in depth to width. The circumstances do not result from the action of the applicant. The applicant did not create the parcel shape or size. And the variance is not in conflict with public interest. Approval of this variance will have no detrimental or injurious impact on properties or improvements in the vicinity. 30 parcels within about a half mile are similar in size to what's being requested. The subject property sits in proximity to 30 others who would require a variance if created today. The requested variance will allow reasonable use of the property similar to the 30 adjacent landowners. Based on the existing density and size of the lots in the vicinity, maybe the area should be rezoned to suburban to reflect the actual density of lot sizes. And safety traffic volume are not impacted. So I just want to go back and really emphasize that an abutting adjacent property was granted a variance for the exact same purpose. And typically it's found that decisions are arbitrary or capricious if you're not treating and applying the same reasoning to applications. So in this case, I want to emphasize that an adjacent lot with the exact same request with to subdivide and split was granted a variance from the minimum lot size, and would put forward that Mr. Valiant should be offered the same opportunity. I would entertain.
I noticed in their application that the applicant had stated client bought the parcel in its current shape and size. They are hoping to be allowed to split the property just like a similar variance to the one you discussed. A recent survey of the property shows the parcel to be approximately 7.9 acres. This is different from what the owners thought it was upon purchasing the property and believe that they could split their parcel in half. What did they originally believe it was? Oh, go ahead.
Sorry.
Could you stand up and state your name, please?
My name's Katie. I'm from Glahe and Associates. I'm working with Jeremy and our client,
Okay.
the Valiants, on this project. I believe the client, when they bought the property, thought it was closer to 9 acres. Thus, such a large variance wouldn't be required. It would just be more because I believe a certain percentage under,
Administrative exception,
yeah,
probably.
that's the word I'm looking for. An administrative exception would have been the route for this instead of a variance.
What led them to believe that it was closer to 9?
The documents that were provided by their realtor.
That's
So unfortunately.
And is there, no, that's good enough. Thank you. You sure? Yep. Okay.
Sorry.
No, that was, thank you. I don't think I need. That was the only question I had. Thank you. Sorry, Jeremy, making you wait while I write. Okay. So at this time, did anyone come in between these files that did not hear me read the rules of testimony already? I'm not going to repeat them if that's okay with everybody. So at this time, I'm going to ask if there is any written statement that anyone would like to enter into the record. And supporting public testimony, is there any in person or online at this time? Or anyone that would like to step up with supporting? Okay, any neutral testimony? Online? Go ahead. If you please step up to the mic, state your name.
Yeah. Okay, Randy Stoltz for the record. And I'm going to go ahead and continue to remain neutral on this and phrase this more in terms of questions, either for staff or for Mr. Grimm. But I'm concerned about precedent. Mr. Grimm laid out a pretty good case that leads me to believe the litigation may be under consideration here. The staff cited larger lots in the neighborhood. Mr. Grimm cited 30 lots in the neighborhood that were already at variance from what this had been zoned as. And I'm concerned with what I see as a recent trend around the county under this particular comp plan that is extant right now, that we are overly reliant on variances, and that if this neighborhood is drifting in the direction that I see happening here, then maybe R5 is no longer the appropriate designation for the neighborhood. And rather than continue to kick the can down the road and continue to have variances, all over the place in this neighborhood. I mean, there are also larger lots, that are still, I thought I saw an egg 20 in there. So I'm questioning, first of all, if R5 is still appropriate in that neighborhood. Secondly, are we really relying heavily on variances throughout the county, not just down in the Bayview area? And thirdly, like I said, I think this continues a bad precedent that was set apparently a couple of years ago under the previous director. And if I was correct in hearing, staff recommended denial on this. And I'm tending to drift rather than being neutral in support of denying it as well. Thank you.
Thank you, Mr. Stolz. Is there any other neutral testimony in line or in person, online or in person? Sorry. Okay. Thanks, Jenna. Is there any opposing public testimony in person or online? Okay, please step up and state your name.
Hi, my name is Kara Ripley. I live at 1684 Bayview Road, right across the street from the subject property. When this gentleman showed all of the smaller lots and justifying the approval based upon that, I would like to know, when were those lots, and point out when were those lots subdivided? I live in one of them, and our house was built in 1980. So I'm assuming the subdivision happened in the late 70s. How many years ago was that, before the current zoning? We have current zoning for a reason. It is our confidence in the planning department because we purchase out there for a reason, to have a certain lifestyle, to have a certain type of home to raise our families in because of the zoning. That's something we looked at specifically when we were out there scoping for houses. We drive 70 miles an hour on the highway for a purpose. We drive 25 in other parts of the city for a purpose. And there is a purpose to our zoning. And I think it's there for a reason. I do think it also sets very, very dangerous legal precedents, especially when the lot just sold down the street that is very buildable on the corner of 95 and Bayview. This is going to set precedents for that, legal precedents where builders are going to come in and they're going to hold you guys accountable, saying, well, you did it for that one, just like he did. Oh, you did it for this guy 2 years ago. You got to do it for us. And it's not, in agreement with the current zoning. And, we're always asking for these exceptions and these variances. And I think it's not a way to preserve Bonner County. And it's not the way we go about preserving Athol, that part of Athol especially. We're all out there for a purpose. I have water rights that I just filed across the street. Another well goes in. I'm assuming he's going to sell it. I'm assuming the subdivision is for the purpose of selling it eventually. Is that another well, another septic tank? Some of our wells are getting drier. And that's something we all have to be serious about considering, and not just rubber stamping everything and becoming Kootenai County. That's why we didn't buy there. We were here and we love this place and we want that area to stay that way. Thank you.
Thank you. Is there anyone else that is online or in person that has opposing public testimony? Please go ahead, state your name, and you can adjust that if to get it to you.
Cindy Brannon for the record, and I live on Bayview Road within a mile of this property as well. And as just stated, many of us have bought property in that area for the specific reason that it is in 5-acre parcels or more, greater. I saw many of those little properties that were divided off appeared to have no structures. And more than likely, neighbors are taking those little parcels and protecting their own property and the boundary lines around them, because that is mainly the way most of the neighborhood feels, is they want the land around them. They want that specific area around them. And the ones that have gotten split, a lot of times we aren't aware that what's going on. I didn't get any notification where I am. I just had a neighbor that was in that area tell me about it. And they said they couldn't be here today and asked me if I would come represent. And so we are concerned about the fact that variances are given for these divisions, especially if it looks like it's going to be another family or another home being built on these small parcels of land, and it is not desirable for us.
Thank you.
Mhm.
Does the applicant have any rebuttal that they'd like to present?
Jeremy Grimm for the record, representing Mr. Patrick Valiant. So, you know, I thought Mr. Stoltz's comments were great. And, you know, I think as the county goes through their comp plan revision, their future land use map and their zoning, this is an area that, based on the 30 parcels that were created, either legally non-conforming or through other means in the vicinity, clearly this area is one that doesn't reflect the 5-acre minimum lot zone for the rural residential. So I think that does have some validity in terms of future work for the planning department. Speaking specifically to the concerns that were raised, in the rural 5 zone, you can build an accessory dwelling unit, you can build a watchman's unit, you can build a caretaker's unit, you can have recreational vehicles, all that effectively densify the structures on a lot. So if this were to be approved, a single family residence on the new lot would really not materially affect the potential density that the current owners have to build outbuildings, accessory dwelling units, caretaker units on that lot. So I don't think there's a huge densification or change in character compared to what could be built in terms of structures on the lot. But I really want to focus on the components that relate to the variance that was approved adjacent to it. And I know this is well, it is what it is. The county had an identical application seeking the identical request, a variance for, there it is, requesting a minimal lot size variance of 20% for the subdivision of a 9-acre parcel into 2. 1 5-acre, which is exactly what we're doing, and 1 remainder parcel. So when you look at what the historical actions of the county were and the basis of decision, the conclusions of law, and you look at what this application is requesting, it is virtually identical. So in light of that, I find it to be arbitrary or capricious to grant 1 adjacent but deny 1 because it's a different day, or a different neighbor turned out, or somebody with clout speaks in favor of 1 or doesn't of another. So that's where I'll leave it, and appreciate the consideration.
And I apologize, I forgot to ask if there was anyone in the audience who did not sign up to speak that would like to enter any comments into the record. Okay. All right, then at this time, I'm going to close the hearing to public testimony. Oh, yeah, please. Sorry, bumped you. I'm not closing yet.
Okay, I thought I was special. Okay, so again, Tyson Lewis, Bonner County Planning Department Planner. Just kind of want to respond to some of the comments and some of the information that's around. I did a little background research on deeds on the properties that are adjacent to that. Any one of those properties that was created after November 18th, 2008 would be subject to a violation and potentially notice the title. We hunt those kind of properties now. Prior administrations, prior departments may have had more lax requirements. But as far as those 30, if any of them were created after 2008, then that's something that we would pursue. Under current code, the creation of any of those lots would be very difficult and if not impossible. You have to prove a circumstance under which you have no control in order to be able to create those. It can't be a special treatment. I'd like to respond to the administrative variance that's to the southeast of this property. There's 3 tiers of variances. There's an administrative exception, and the administrative exception is good for about a 5% deviation in lot size. 1 foot dimensional standards from shoreline setbacks and 5% of, other property line setbacks. Then there's an administrative variance, and an administrative variance is 1 tier up because it goes to a 30% deviation of pretty much any of those things. And an administrative variance does not have to be, it doesn't have to go through a public hearing. A lot of people in the past have tried to opt for an administrative variance by lowering their expectations in order to avoid public hearings, because public scrutiny, then all these things come out in the light. That property that is to the southeast, if we were to look at that now as an administrative variance, it'd be considered because they're closer to having the 10 acres that would be required to make 2. Also, that lot's not creating a lot that's encumbered by double frontage, where this existing lot, the existing parcel, is encumbered by double frontage. So creating the 3-acre lot not only adds a property line setback, but also it would still be faced with double frontage setback issues. Current density in R5, each one of those lots would be allowed a total of 4 dwelling units. 1 single family dwelling as large as they like, 1 accessory dwelling unit, 900 square feet of living space or smaller, can be above a shop, and 2 recreational vehicle dwelling units, which can also be tiny homes. They can be on a foundation, and they also have to be 900 square feet or smaller and no more than 2 bedrooms. All of those would then be required to meet the required 25-foot setback on either side to those streets, which could be fodder for another request for a variance of a future property owner who has their own property rights. So the planning department direction now is, if we can avoid creating lots that, produce further encumbrances for future owners, it saves headaches for future property owners, as well as, it's already a non-conforming property. So to increase that non-conformity, it's not really something that we would want to approve. But that's not our decision. We can only recommend an approval or denial. So that's what we did. So I don't know if you have any other questions based on testimony or rebuttal.
When you mentioned the administrative exception, would that, and you said it's up to a 30%?
5%.
5%.
An administrative exception does not need to be routed to the public. It doesn't, it's kind of a gimme. And that's only 5%. Where the administrative variance is up to 30%.
I said the wrong.
So the administrative variance does get routed to agencies. It does get routed to neighbors. And it's a little bit more of a thorough review process. The department now, the way administrative variances are, reviewed, I'd say we probably have a 25% denial rate, if not more than that. It may not have been like that in the past, but I know the direction we're going in now is more thorough reviews, and there's no precedence as far as variances are concerned. It's a case by case, property by property basis. We don't really take into account what other people may have done in the past or what they've had. We have to review them dispassionately and case by case. So that's kind of where we're at with them now.
So if this had come to the director at the time, would that administrative variance fit that 30%? It wouldn't.
Well, are you
Because
talking
that-
about the other property?
No, this one.
This
in
property?
consideration.
Yeah, it's still above a 30%
That's what I was
deviation,
thinking.
so no
I
matter
know
what,
there was some
yeah,
Changing in the numbers, so.
yeah, it would still require a full variance. And
Thank you.
also both the deviation from depth to width and the deviation from lot size exceed 30%. So that other property, it was just lot size. So you have
Right.
9 acres to 4.5 acres where 5 is required. Yeah, that would qualify for that 30% deviation.
Thank you.
Mhm.
Sorry for booting you before I let you speak. Okay, so now I'm closing this hearing to public testimony. Okay, thank you. Okay, there was a lot thrown at this one, but I agree with what Tyson was stating up there, that this application does not, oops, sorry. That's what I was gonna say. It does not present any unique conditions that aren't already existing in the area. There's already been development on this lot. And I do agree with comments made by the neighbors. It was zoned rural 5 for a reason. People want to live in their rural 5 for a reason. They choose these areas for a reason. These smaller legal non-conforming lots were there prior to 2008, I believe is what was stated. Okay, so it would not be, I'm just blubbering. It would not be something that a person could go out there now and say, okay, I want to buy a 2-acre lot and I'm going to go look in this area, because that's not going to exist. And I agree that the rural 5 designation should be upheld out there if that's what was originally established, and not continuously split up into smaller lots. I would say that as far as the realtor is concerned, kind of a buyer beware, do a little more digging into your research. I guess when you purchase these properties, if you're thinking down the road that you want to subdivide or split your property, check it out, check into the codes, make sure that that is something, that you can do. I feel for them though, if they were unfortunately misled. However, that has really no bearing here. 2 of the 3 conditions were not met, and therefore I am denying this application. So I hereby deny this project file V0022-22 requesting a minimum lot size and depth to width ratio variance based upon the following conclusions of law. I have to insert those. Which are stated. Do I need to read those where he said in? Okay, thank you. That threw me. Where was I? The decision is based upon the evidence submitted up to the time of the staff report was prepared and testimony received at this hearing. I further adopt the following findings of fact and conclusions of law as written or as amended during this hearing. The action does not result in taking of private property. The action could be taken, if any, to obtain the variance is to file a new application with the planning department and meet the standards required by Bonner County Revised Code, or appeal the hearing examiner's decision to the county commissioners. Okay, so at this time, I am closing this file. I need to find the number. V0022-22 variance. Okay. Thank you all for that. Is there any schedule reminders, updates, or announcements that I need to? Man. So much info came at me.
Schools. My parents were, mom's still alive. His parents are in jail. Yeah,
I'm sorry, guys, we're still.
Really a lot of my, I'm sorry.
Thank you.
Oh, that's mine. Like someone left their water bottle. That's mine. The one change you're gonna see in the next round is that staff reports, they're essentially a persuasive argument, right? That leads to a conclusionary statement. That's the way I've always seen them. In this case, you have a staff recommendation at the very end of approve or deny. We're gonna kind of shift that focus a little bit in how we conclude our staff reports. So you'll see like a staff conclusion, and you'll see it's inconsistent, or it is consistent or inconsistent with the Bonner County Revised Code. So we're trying to lead away from the please approve, please deny, because some of these are somewhat discretionary on your observation during the hearing, your review of the code, and say, okay, no, here's where I find it is consistent, and you can kind of dictate that in the meeting. So just, we didn't want to change on this one without giving you a heads up, but just kind of going forward, you'll see that. So if you see it, and it's, to us, it's, you know, we've reviewed it as a technical analysis, saying this is where our technical analysis was led to. So if you get some evidence during the meeting, switch your mind. So as far as the hearing examiner's authority, it hasn't been challenged in court. It hasn't been an appeal made challenging that. So I'll let you know if that does come up. Like I mentioned earlier, the board did uphold the last variance denial for lot size minimum. My stance is, especially when you're going these kind of lot size minimums, we're going far below. I don't think it's a good argument to say, hey, look, we're a lot like all these other ones around us, because one of the criteria is simply saying, how are you different, right? And then why have zoning, right? So oftentimes you'll see an establishment of zoning placed down where you're seeing density happen that it shouldn't happen, right? So if you're seeing lots under an acre and there's no urban services in that area, R5 zoning does make sense. I don't agree with some of the comments that the R5 zoning should be switched to suburban, because there's no urban services available. There's no potential for urban services. The closest sewer district is in Sagal. So I think R5 there is appropriate. And I think these kind of decisions are going to uphold that zoning. So that's just kind of my 2 cents on that. But that's the one major change, the staff report conclusions. You'll see a little change in the near future. Other than that, we have some new comp plan goals, policies, and objectives that was approved by the board December 21st. Those are available on our website. And you'll see those reflected in the CUP staff reports going forward. We have some other proposed Title 12 changes that I'm going to be making in the near future. You saw one of them today on the definition of lot dimensions. So we have a handful of other ones, and I'll kind of keep you apprised of that. It's going to take a few months for those to get through and hopefully get adopted. So nothing major, some minor changes. I try to do this at every public meeting. We're recruiting for planning commission members. There's currently 2 open seats. So we had another resignation on the planning commission. So if you know anybody,
I don't blame them.
free advertisement's good. So, and no, there's no districts. So I need to talk to you about that. That's fine. Yeah, so it's just 2 open seats right now. So, yeah, I should do this at the beginning of the meeting when everyone's actually here. I'll do that next time if we have openings.
Okay.
So that's all I got.
All right, then I'm going to announce the adjournment of this meeting at 3:05. Sorry, my military time at 3:05, January 18th, 2023. And we are adjourning until February